I have no affidavit, nothing has been given. I do not say what they have. I request your Lordship to read the lead
All right.
as it
All
is.
right.
Therefore, my submission is not confined to West Bengal government. In central government employees, when the commission argued, ask them what 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 was the
All
reaction
right. All right.
in the
Next.
government employees. Yes. Now, on this basis, the argument is based that only state government employees' experience will be relevant. Is not factually not correct. Rule do not say so.
All right.
Yes.
Next.
Therefore, let us now consider the on this basis that uh, of my submission that experience gathered by all government all government aided sponsored schools in a substantive post as permanent or on contractual basis. Must be substantive post.
What does this mean?
That's not they say so. Substantive post, not a temporary post. I am given to understand, my commission correct me, central government employees uh, application or representation for getting the 10 marks were rejected on the basis that none of them held substantive posts.
What, according to you, is a substantive post?
No, which is permanent, not temporary.
So mere permanency should be there.
With a permanent appointed substantive post, must have, which is not maybe contractual, but like permanent, as permanent or contract. Bracket says so. Substantive post means as permanent or on contractual basis.
Right.
A permanent or contractual basis. That's the definition they have given. We have to go by the rules. Without the rules, unless it is declared to be ultra vires, any clause, is binding on the commission, on everybody. And even Milord, we have to say that we have to act according to rules. Therefore, not substantive post as permanent or contractual basis. Now, Milord, it was expected, Milord, the person or the authority person who assail a rule or action, statutory rules presumed to be valid. Onus is on them. Now, as my lord asked me, may I also humbly submit that nothing has been clarified in their argument what is meant by substantive post. They have not said that these untainted employees did not hold substantive post. This is why I'm emphasizing. They say the substantive experience gathered by them as a teaching teacher was under a void appointment. Am I right? So, but this is one argument, legal argument. But the teacher did not hold substantive post. That is not the argument of anybody. So, my lord, if I can satisfy lordship that even a experience or any benefit gathered under a void contract of employment that can be detained by the concerned employee provided he was the innocent party. He was not party to the illegality. This is under law of contract. Supreme Court specifically given, but Supreme Court has not given an illegal order, passed an illegal order. My submission would be, answer is number one answer. This question is no longer open because order of some Supreme Court in Boishagil matter is binding and final and binding. Let us see the order. Supreme Court says, see the order, my lord, the conclusion part. First part is tainted. Similar Supreme Court making a classification between tainted and untainted. That classification was not made by our High Court division bench. That schedule was not made. All and sundry was cancelled. But Supreme Court made this modification. And Supreme Court made a classification between tainted and untainted, two groups. And this classification, as made by Supreme Court, cannot be challenged. This is an order and final. And not Supreme Court has made discrimination, how do you call it, differentiation between tainted and untainted. Now let's see what tainted, they are not entitled to receive benefit of the services they have rendered. But similar, the tainted people, they had contract employment like everybody else, and they render service as a teacher. Question is, why Supreme Court deprived them of the service they have rendered, or the benefit of service, like it said, remuneration, namely service experience, everything. Supreme Court clearly says, can now similar. The last lecture, we find no valid ground or reason to interfere with the direction of the High Court that the services of tainted candidates, High Court has all candidates really, were appointed must be terminated, and they should be required to refund any salary payments received, since their appointments were a result of fraud. This is important, beloved. Fraud to which these tainted employees are parties. This is the what is the instance of tainted candidates? They submitted blank answer papers and got appointment. They knew party to the fraud. No answer given, but they got the appointment. The four instances of the party to the fraud, result of fraud. This fraud is mutual fraud. Commission and the tainted candidates in conjunction has committed the fraud. In case of untainted, they are not party to this fraud. They are innocent parties, victim of circumstances. And Supreme Court making this clear distinction, result of fraud, they will not. This amount, therefore, to see no justice. Therefore, they cannot retain the remuneration even. Now, say in the case of other class, for candidates not specifically found to be tainted, the entire selection process has been rightly declared null and void. High Court declared. And High Court really didn't make a distinction. The entire process null and void, and all appointments are invalid, void. Said so. But Supreme Court now could make a modification of High Court's order. Due to egregious violation and litigation, illegalities, which violates Article 14 and 16 of the Constitution. As such, appointment of these candidates are cancelled. They are being cancelled. Their appointments are cancelled. Appointments are not declared void. If appointments are void, they don't have to be cancelled. See the language, very clearly distinctive language. So the practice was found the entire process of selection process was null and void. Therefore, result is their appointment become voidable, and Supreme Court cancelling it. It clearly indicates that Supreme Court did not consider the appointments to be void, because Supreme Court is conscious of a fact that if a party is not an innocent party to a contract, is not to be punished. Principle of pari delicto. It's the law of contract. Ex tarpai causa. This is law of contract. What is that? It's a contract of employment between a teacher and the commission. The contract is contained in the appointment letter. It's a contract of employment. And pursuant that contract of employment, Everybody served for the period allowed, right, because of delay in the matter. But their two groups are different. One group is serving knowing that their appointments are they have been fraudulent, party to the fraud. Other group is serving on the basis that, and if I say legitimate expectation, that state actions are honest and valid. Let one Mike, Mike.
Nothing
No.
to do with this case. Nothing to do with this case. It is for you. Mr. Mitro argued in that 33,000 matter. In fact, all of us, Advocate General, we, just a judgment has been delivered.
Delivered.
33,000 teachers, their services are protected.
I'm very happy.
That's
I'm
I
very
thought.
happy. Yeah, I good
Because
day,
Mr. Mitro also appeared. I also appeared.
আপনি all appeared.
And it was
Today,
just
আজকে এসে বলছিল অর্ডার জন্য কি হয়। But I was sunset after my argument, nobody consulted me. ঠিক আছে। And I'm very happy because 30,000
I knew that's
primary, that is primary education. Now, may I go on with this, Milord? Primary. Milord, there's a, apart from the Supreme Court order, I don't have to should not argue more. But it has been argued, that's why I have to give a reply. These were cancelled. The next line, however, the candidates who are already employed need not be asked to refund or restitute any payments made to them. Benefits under their appointment are being allowed to be retained, which cannot be done in case of fraud. It can be done only under a contract which is cancelled. But both the contracting parties are not fraudulent. There's one innocent party, and commission definitely is a party at wrong party. The employer. Definitely, no. So, Mila, this is being retained. This cannot be challenged by anybody. Final. Therefore, Mila, in my humble submission, the selection process may be null and void. But appointments, contract of appointments of employment entered into by the commission and the employee teacher has different footing. It will be voidable if discovered to be void later on. Also, side judgment if necessary that two things are here. One is Dr. knows the theory of quantum merit. I deserve as I deserve. So, if a service has been rendered, there is no allegation, at least no argument anywhere, that those untainted candidates did not teach properly their delegation duty. Students were not benefited by their teaching. Their performance under a contract which is being cancelled after 7 years, their performance is not below standard. This is one instance, Milord, where Supreme Court completely. However, see, their service will be terminated. Service will be terminated. Terminated, not void. It was voidable at option under order of court. A selection process declared void, but appointment made thereafter not declared void by the Supreme Court. It is cancelled by the court. It is terminated by the court. They may be similar. Furthermore, no candidate can be appointed once the entire exam process results have been declared void. No candidate appointment once. Therefore, appointment cannot continue. Appointment must be terminated, must be brought to an end. Because the result has been declared void. That should be clear. Appointment must come to an end. And it is being brought to an end by an order of court, not void, null and void, no void from the inception. That was similar next thereafter. See the next paragraph. Further benefits, other benefits retained by the teachers, I mean untended teachers, are being allowed to be retained. Kindly similar paragraph 47. Sorry, clause 47. Yes, 47. Some appointed candidates who do not fall within the category of tented candidates may have previously worked in different departments of the state government or with the autonomous bodies, etc.
But this paragraph will not be relevant
Lord,
in this case.
please see, my Lord. Just 1 minute more. Although their appointments are cancelled, these candidates who have the right to apply to the previous departments or autonomous bodies to continue in service with their entities. These applicant must their applications must be processed by the respective government department or bodies within 3 months, and the candidates will be allowed to resume their position. Further, the period between the termination of the previous appointment and the rejoining will not be considered a break in service. This is important.
No, this is not for you.
Lordship, construing order of court. Question is whether the benefit of that service made under the contract which later terminated has been allowed to be retained by untented. And this benefit allowed to be retained. Why not the experience then? Why not the experience then? And this tented people, they are being allowed to retain their experience. Their service is being continued, not a break. This is very important. That tented employees, some of them had served previously, maybe government, other government institution, independent bodies, etc. And they gave up that and joined this West Bengal school services. Supreme Court is very clearly saying, this is important, my lord, the period between termination of their previous appointment and the rejoining will not be considered a break. Then their seniority and other entitlements will be preserved and they will be eligible for increments. This is a sign of saying called treating null and void. Being allowed specifically. Now, here it doesn't matter whether I am appearing for any of the employees or not. I'm appearing for the untended employees. Untended employees. What has been Supreme Court intention is clear that untended teachers will be allowed to retain the benefit of their period of service, including the period, their seniority, and their entitlements will be considered as if they had continued in the service of the old employer. What does it mean?
That means the old employer.
Yes. We'll continue them.
Old employer, you were not in old employment. You are not at par with this.
I appreciate it. Correct. Old employers will do it.
Yes, that means
Why the old employers are allowed to do it? Why the old employer cannot say you are in a void employment? I shall not give you. Void employer, I shall not give you the benefit of resumption, continuation. But it is not, I am asking for this. I am order of Supreme Court has to read as a whole. There is no question of anybody else. If you read the order as a whole, then Supreme Court is expressly allowing those untended candidates who had given up other employments to rejoin their service. Number one, very good. And to retain the benefit of serving in the school of the West Bengal government, period of 5 years, 6 years maybe. They're allowing tented candidates are being allowed to retain benefits of the period of service under government. Benefits were seniority, one of them. the seniority will remain. Although, how can it be then? Appointment is void. Appointment void. Therefore, how the seniority could be retained? Therefore, all that I'm saying, this all indicates that Supreme Court did not consider or did not hold the appointments were null and void. That's one important point I'm linked to. If appointments are null and void, patented, then regardless of whether the government employees came from another government institution or not, would be irrelevant. If those tainted employees who came from in the independent institutions are being expressly allowed by Supreme Court to get the benefit of the seniority
All right,
of
I
the
got it.
period of service.
Next point, please.
This is Milord. Next paragraph. Another paragraph which clearly says another thing. Paragraph 49. Disabled candidates mentioned in the previous paragraph will be allowed to participate in the fresh selection process if required, with age relaxation and other concessions. Similarly, other candidates who are not specifically tainted will also be eligible to participate with appropriate age relaxation even. Age relaxation, I'm emphasizing on this. Age relaxation will be allowed.
That has been allowed.
Yes, it has
been allowed.
emphasizing on that.
Right, it has been allowed.
That's Supreme Court allowed that. What that indicates, therefore, Supreme Court says Supreme Court is paying the full weightage. Supreme Court is giving full weightage to the service rendered by the untainted candidates, to their period of service under so-called cancel appointment. I'm on the Supreme Court, weightage is being given. And then why not teaching experience? That's also an advantage. Now, argument is, therefore, the selection process was null and void. Therefore, teaching experience is also null and void. See the logical legality of this argument, logic of this argument. Is there any logic behind this? If they're null and void, then they should not get any service, employment. They should not get any salary. They should not get advantage of their seniority. They should not get any advantage to appear again. They should not get age relaxation. They should not get age relaxation. These three things, cannot be given. This benefit cannot be given unless Supreme Court decided and clearly decided, intended to decide that weightage should be given to the period of service rendered by these untainted employees. And this is said very clearly by saying, retain your remuneration, retain your seniority, if you are coming from another thing, and there will be age relaxation for you for the period of 5 years, 6 years you have spent when you are appearing in real service again. This opportunity, eligibility to appear in the first selection process is not given to tainted employees. Not to tainted employees, but given only to untainted. So a clear classification is made that there's a difference between tainted and untainted employees. And this is the order. Kindly read paragraph 51 also. Accordingly, we uphold the impugned judgment, cancelling en bloc entire selection process. What is selection process is not cancelled en bloc, but have made certain modifications in the direction issued by the High Court. So, that means selection process cancelled, but modification is made in direction of High Court. Therefore, my lord, our division bench, when faced with a contempt application, they said, my order is merged in the order of Supreme Court. Therefore, to go to Supreme Court for contempt of court. Yes, this paragraph 51, modification means order of division bench of High Court merged in the order of Supreme Court. Order of division has no existence now. No independent existence now. Yeah, we have whatever see this final order. That means you may refer to for any purposes, but what you like.
Refer to where?
You don't refer to this order of division, High Court order, for asserting the rights of the people, ascertaining the rights of the tented and untented teachers.
I didn't get it.
My lord?
I didn't get it.
No, because order of High Court has no march in the order of Supreme Court.
Yes.
This is the only order you have to see and determine the rights.
Right.
The rights. Whatever High Court has said.
Yes.
But that has been modified by the
Yes.
Supreme Court. So, my lord, I am referring to it because, my lord, I found my learned friends or petitioners or reading substantially from Justice Division Bench order of the High Court.
Yes.
Why they're reading it? I am objecting to that, saying that that is not there. It is not the Supreme Court order. Read the Supreme Court order.
Yes.
Supreme Court judgment and say whatever you want to say.
All right.
But not the reading from High Court order, which has merged,
Yes.
has no separate existence now. That is why I pointing out to Lordship. I am answering the argument made the other side. My Lord is right. That should not have been argued at all. That should not have been argued on the basis of the division judgment of the High Court.
Yes. Next.
Yes, Lordship might have stopped them. But not allowed to argue, therefore I am giving a reply. Today I am giving a reply point by point. So, now let us come to the point. What is the then basis for the argument that teaching experience gathered by those untented candidates during the tenure of service under the school should not be given?
Since you are referring to the Supreme Court order,
My lord, yes, my lord.
please also refer to the order of 17th April 25 passed by the Supreme
Yes,
Court.
yes. That's right.
Please come to that order also.
Division bench order, my lord.
Supreme Court's order.
Yes, I'm holding it, my lord.
17th April 25 order.
Which paragraph, my lord?
Page 108. In the writ petition, I can see.
Separate order, another order, no?
Yes, it's a separate order.
Separate order, I see. Then and let me close this. Yeah. Yes, my lord. No? Order dated? Order dated?
17th April.
17 April. Yes, I've got it, my lord. I've got it, my lord. We inclined to accept the prayer. That's how it begins.
Yes.
We inclined to accept the prayer made in the present application insofar as it relates to assistant teachers for classes 9, 10, 11, 12, not found to be tented, subject to the following conditions.
That means you fall in this category?
Not?
You fall in this category?
Yes, this is found to be not tented. Accept the prayer. Prayer, what made one application was, he prayer made করেছিল. Yes, that's right. And
so you fall under this category?
Yes.
You are not found to be tainted?
Yes.
Right?
Correct.
Please come to that order at after paragraph 4 in the next page.
Yes, we know. 4.
We clarify that.
We clarify that. This order we shall not be read as conferring any special right or advantage on the apostate teachers, insofar as fresh recruitment process is concerned. Correct?
What does this
Correct.
mean?
No, that's why I am not saying that this order, I am confined. I said the order in Boishali's case had conferred some advantage and right on the untented. I'm confined. My argument is this. I am blessed with Lordship. Under the order in Boishali's case, but some advantage and rights have been conferred on the untented candidates. And those rights have not to be interfered with. I am not asking for any further right under further orders of court. Supreme Court has lastly said the order of Boishal is final. And I am confining my argument to the rights and benefits conferred by that order, not by this order. Let's go in. I'll go into so far as concerned, no special advantage. With these rights, whatever has been confined was conferred by the Boishali judgment.
This is in the same matter.
With all the rights and benefits that have been conferred upon us by the Boishali judgment, we shall participate in the fresh selection process.
Yes.
This is the point. With whatever rights and benefits conferred upon us by the Boishali judgment, with those rights and benefits, we shall participate in a selection process. We will not divorce the rights and benefits conferred by the selection process. The argument is entirely on the basis, on the friend, with my respect, that as if we shall participate in the selection process, divorce the benefits and rights conferred by Boishali judgment. It is not Supreme Court query insofar as this is the point. This is the fallacy in the argument with respect that the rights and benefits, with those rights and benefits, with confidence, we shall participate in the fresh recruitment process, not divorce those rights. And one of those rights is the benefit of the service you have rendered, including everything, and which include experience and seniority and teaching experience gathered. That will be gathered. So, my lord, point is that our service as untainted teachers, the rights and benefits conferred by Supreme Court, that's why I am placing that order. They have given the right of retention of the financial benefit, giving the right of retention of financial benefit. They are giving the right of retention of the seniority benefit as and when necessary for those, as when necessary for seniority benefit. They are giving the benefit of age relaxation for those who want to participate in the fresh selection process. Similar in the fresh selection process, the freshers will come with particular age qualification. But this group, untainted, will have higher age, older age, they will be allowed to participate. Similar, this is a class by itself Supreme Court has created, and there is no classification within that classification. Well, I am only saying, kindly see, as Supreme Court has said later on in a judgment order, I find, the rights of the untainted should be preserved. Now, my lord, Lordship has been shown the last but one order, order dated 23rd November, no? 26th November. Which means the Supreme Court, it says the court of first instance, let them decide. Because it is very orthodox approach by Supreme Court.
Should not have been.
Orthodox approach.
Should have been.
I am happy.
No, this orthodox approach should not have been by the court.
No, that is not. I'm not saying that. But it was orthodox approach, Lord, because the court, usually appeal court always said that's the benefit of the first court. You will also sitting in division will say that the benefit of first court. Supreme Court saying, let me have a benefit of the views of first court, who will go into the facts of the matter more deeply than appeal court would. So Supreme Court said, let the first court decide, which is the benefit of it, then matter comes up, we shall enjoy that benefit. But Supreme Court did not want to deprive himself of the benefit of the wisdom of the first court. And please see the last paragraph last page is very important. The Supreme Court has said, I'm very happy and proud of our High Court. They have reposed so much of confidence in the High Court. The High Court shall examine the matter uninfluenced by any of the observations or merits made by this court in the orders passed after decision in Boishal Judge. Whatever observation made on merits, etc., and Boishal that High Court will not touch. But not High Court, Court is High Court, Supreme Court is reposing so much of confidence. I'm happy. Calcutta High Court, after a long time, is gaining some importance that by any observation made for a court. That shows my degree of confidence the Supreme Court reposing in the High Court. That I'm proud of that. The next paragraph. The High Court shall also be mindful of the fact that untainted candidates in the past selection were allowed to sit for the selection tests to be held afresh, and their candidature cannot be adversely affected by application of the new rules. New rules should not be construed in a manner which would adversely affect them. This is not humbly pointing out. Supreme Court is merely clearly making a classification, and Supreme Court sympathies for the untainted candidates are apparent. What does this mean? That the effect and candidates cannot adversely affect the application of new rules. That is, West Bengal, the school rules is mentioned 2025. So, my lord, while construing the rule and applying it to the candidates, please ensure that the 10 untainted candidates, their rights which have been given by the Supreme Court under the order of Boishali judgment, and their selection test allowed to sit is not adversely affected by the new rule. It does not, what does it mean? It may understand it as I have understood. Even the commission, by making new rules, cannot take away the rights and benefits which have been given to the untainted candidates by the order in the Boishali case. It is clear. If the commission has made any rules which will adversely affect the rights and benefits given to the untainted candidates by Supreme Court in Boishali judgment, then the rule will not valid, will not adversely affect. Even the commission making rules cannot adversely affect that right and advantage given. So, while discussing the validity, legality of the rules, kindly bear in mind this interpretation about Supreme Court. Ensure that no right given by the Supreme Court by the order of Boishali's case can be adversely affected even by the new rules. New rules has to be read in that fashion, in that manner. May I place a
Yes,
judgment regarding contractual fee? The innocent party is not affected by if the contract has become void.
Will it be required? I don't think it will be required. Now it is up to you what to
This
cite
innocent
and not
party
to
is not
cite.
to be affected by termination of contract.
It is up to you. I will not stop anybody from making any submission because,
Well, I get the proposition given lordship.
right,
I judgment cite later on.
it is up to you, sir. I won't stop you.
1960 Supreme Court case that I am relying on All India Reporter 1968 Supreme Court 1165 at page 1176. 11 at page 1176. এটা আমার বইটা দাও, তোমার তো পেজ মিলবে না তো, তুমি এসিসি লিখে হবে আমার বইটা দাও, তো পেজ মিলবে না। Losses has been given. Well, I have read from my reported AIR. What the page bolu? 1176. 86 দিচ্ছ তো, 86 না 68, AIR 1968 Supreme Court, 1165 at 1170, the continuation of paragraph 11, sorry মিলট ডিলে হয়ে যাচ্ছে, বুঝবে, তোমার বই ফেরত দিয়ে দিই, নিয়ে নিচ্ছ তো, ভলিউম টুতে ছিল, কি কোথায় গেল ওর লোকগুলো, কোথায় গেছে বইগুলো, বাদ করে দিন। 1968 Supreme Court. Paragraph ওটা মিলবো, একটু বইটা খুলে বাদ করে, better will not waste my last time. Cite this judgment later on. When will later on. আজ বাদ করে রাখবে, প্যারাগ্রাফ নম্বর থাকে না, অন্য জিনিস। Now, may I now deal with the argument that the mark 10% marks given to teachers of government schools is bad. That is the main thing. I'm using expression government schools because the rule do not say West Bengal government schools. Rule do not say that. No. What are the grounds are good, and I shall deal with that right now. What's the test for determining? It is said to be altered by this arbitrary Article 14. But what is test for determining the marking process? Because this is not eligibility criteria. Anybody can come. One need not have teaching experience for making application. The gate is open to all candidates, whoever. There is no restriction on that aspect. It is regarding marking of the merits, marking. And that may not be done, it is declared beforehand. The rule of the game has not been changed. That was declared beforehand. Those who apply for this post, they are expressly told that this is governed by the rules of 2025. And they know very well that those who have teaching experience of government schools will get an extra 20 marks, 10 marks, 10% mark. With knowledge of that, everybody has joined, including candidates who do not have any teaching experience, and candidates who have teaching experience. This is transparent, nothing clandestine. Now, with this knowledge, they are participating. Everybody participated. Now, what is the test for deciding? Well, I'm hard, arbitrary many times, unreasonable many times. But what test for determining this? Let me in a humble submission. The test is that this marking system, what we marking, should have a reasonable nexus with the object and purpose of the rule. So, Lordship should have been addressed, showing what is the object and purpose of the rules. And then Lordship should have been addressed that this is the object and purpose, and the 10 marks for teaching experience has no nexus with that object. With utmost respect to all my learned friends, they have not argued on this, they have not touched on this aspect. But this is the fundamental rule of declaring anything a violation of Article 14. Any condition imposed which has no reasonable nexus with the object, that is arbitrary, not anything.
Yes.
Now, my lord, in a system, lots of us seen in tender matters mainly, lot of conditions are given that you come, but those who have financial capacity of more than 6 crores will get this additional advantage. Those who have supplied similar goods to other government companies, they will have this additional advantage. That is not eligibility criteria, but additional advantage. No court has held that to be invalid or illegal unless it was shown to the court that 6 crores financial capital has no nexus with the object of the notice. If the suppose is a contract for value of 50 lakhs and the condition imposed must have 6 lakhs, then that will be struck down, no doubt. So, case is reasonable nexus with the object. Now, what is the object of this rule? These rules framed under section 17 and 8 of the Act. Please see this Act below. Although they have not argued, I am arguing this point. তো আর্গুমেন্ট করেনি পয়েন্টে এরকম তুই বলেছে নেক্সাস নেই বলে আর্গুমেন্ট করেছে কেউ অনিল রায় এখন ফোন করে জানাচ্ছে অর্ডার হয়েছে ওনার হ্যাঁ না মুশকিল করছে এখন আর্গু করছি রেখে দাও থামছে এটা বোর্ডগুলো থামে না হ্যাঁ that section 8 I'm drawing my attention to because in that rule it is mentioned exercise of powers given as 8 and 17 both 8 below section 8
Is it annexed anywhere?
of the act of the parent act
Yes, is it annexed?
Dr. Guru Swamin's compilation.
বলে দাও
Up
to
the compilation submitted on the other day by Dr. Guru Swami.
কোথায় পাবে এটা ওয়েস্ট বেঙ্গল কোথায় পাবে একটু বলে তো এটা কোথেকে পাচ্ছেন এইটা তো
Is the matter in the list today?
Yes, my lord.
Which item?
Everything is running. Item number 19.
Item?
Everything is 21. Item 21.
দেখুন তো ওই স্পাইরাল বাইন্ডিং গুলো আছে না একটা স্পাইরাল বাইন্ডিং আছে ব্লু কালারের একটা স্পাইরাল বাইন্ডিং আছে Yes, please.
Well, it's Act Miller to provide for General School Service Commission. Object of the Act Miller, I, I humbly submit, is to find or find out or select suitable persons as teachers of the government school. That is the object and purpose, to select suitable persons for government. Now kindly come to 8, Section 8. Manner and scope of selection of persons and procedure for conduct of business or commission. The manner and scope of selection of persons for appointment to the post of teachers shall be such as may be prescribed. Prescribe means by rules. The section 2 provides the prescribe means by making of rules, not by regulation. Not by regulation. The prescribe is defined under this, as usual, Lordship knows definition. Fine, Section 2K.
Yes. Enter দিন, enter দিন.
Second,
Yes.
It's at page 495 of the compilation part 1.
Yes, please.
the manner and scope of selection of persons for appointment to the posts of teachers shall be such as may be prescribed. See the next paragraph. The procedure for the conduct of business or commission shall be such as may be provided for regulation. So, regulation and rules operate in different fields. This I am pointing out now because the argument was made by some of my learned friends that these rules are violative of regulations, isn't it? That's why I am pointing out, they operate different fields. And I'll come to later on. I showed you the rules provide that the regulation provides any rules regulation will be subservient to the rules. In case of conclusive, rules will survive. That is also position. But that is argument come later on when we deal with this. Section 8 is as may prescribed. So delegated power. Then section 17. The two sections are referred to in the rules. At page 497 of that compilation. State government may, by notification, make rules for carrying out the purposes of this Act. Purposes of this Act. In particular, without prejudice, terms and those are things, other things. And regulation now 18 will not. Central government may, with the previous approval of state government, make regulations not inconsistent with the provisions of this Act or the rules made thereunder for discharging the functions of the Commission under this Act. Central Commission may, and makes it very clear that the rules and the regulations work in different fields and regulations are subservient to the rules. So no good argument that the regulation and the rules are inconsistent. If that is so, rules will prevail. But argument has been made elaborately, regulation, etc. Regulation, rules, new argument, regulation ultra values the regulations. Rules are ultra values regulation. Inconvenient regulation. Their argument, I do not know whether that case is made out in writ petition, but that argument may not has to be rejected without applying in further mind. Now, this is the position. This teaching experience has it got with the suitability of the teachers, selection of teachers? That's the point. Now, firstly, giving some extra marks for teaching experience has been very usual. Is not only this commission. Various other institutions have made similar provisions. You might just take our affidavit. We have given some of them. Dr. Guruswamy also mentioned that UGC regulation rules. And we have in our affidavit.
Affidavit in opposition file.
বলো
মানে একটা affidavit in opposition file হয়েছে।
এটা রাখুন আলাদা। হুম।
কোন প্যারাগ্রাফটা আছে প্যারাগ্রাফটা দাও আগে।
Right?
As Shoykot Montu. Affidavit in opposition in Can 1. The name of the party is Shoykot Mondol, the added respondent.
Can one in this matter?
Can 1 in Lubana.
In Lubana? Opposition? I don't find the opposition. Has it been recorded in any order?
What the record?
Monday?
কি বলতে শোনো আমি দেখি দর্শক কি বলতে শোনো।
On Monday, it was listed as item number 20, Malats.
Yes, I can see it's recorded. Can one opposition filed? Can one এর oppositionটা কোথায় আছে দেখুন তো কার সাথে গুলিয়ে গেছে। Point out from there.
বেশ দর্শক কি বলছো শোনো।
What you want to point out?
Yes, we want to point it out that it's not the West Bengal School Service Commission.
So you've annexed documents.
There are annexed documents of various other universities granting the experience.
All right. I take it. All right.
আপনি পাওয়া গেল না?
It will be found out, sir. It may have gone mixed up with
Okay.
some other file, but then I take that it is a usual
Document
practice.
that we have stated at page 8, paragraph Roman 8.
All right.
It has been marked as annexure D,
And the annexure B.
not B.
No,
sir.
sorry, B, no.
D.
D. At its annexures are at page,
The relevant pages.
yes, page 60 onwards.
All right.
আর অনেকগুলো আছে এটা কি প্রথম?
তা প্রথমে এটা থেকে-
Firstly, Miller to a given. এটা কোথাকার এটা কাদের? Register UHS.
This is University of Karnataka.
First is page 60, University of Karnataka. They have granted experience in teaching is 5 marks. They have granted. And the next instance have given the assistant professors,
Sir, এটা
etc.
continue হচ্ছে, অন্য আরেকটা ইউনিভার্সিটি বার করে
হুম?
দিচ্ছে। এটা কন্টিনিউ হচ্ছে, অন্য একটা ইউনিভার্সিটি বার করে দিচ্ছে।
No. কোথায়? Higher education, F2 department. কোথায়? একটা annexure কি?
Page তামিলনাড়ু কলেজ।
Page 65 again. Page 65, the Tamil Nadu Collegiate Education Department, Tamil Nadu. They have given this experience, teaching experience, 10 marks.
This is page 71 and page 70.
And again, another one, page 71. That Tamil Nadu Education Department, 10 marks. They have given this experience, teaching experience, 10 marks. And again, another one, page 71. That Tamil Nadu Education Department, 10 marks. They have given this experience, teaching experience, 10 marks. That is experience, teaching experience. We are given about 3-4 universities, below.
All right.
ওটা দিয়েছে, 3টে দিয়েছে। গুরুস্বামী তত দিয়েছে।
Page 49.
পেরে দাও।
Another example is cited at page 49 of our affidavit in opposition.
Yes.
We have given 4 instances. And Dr. Guruswamy has also given,
Experience in UGC.
has given a list also, addition to that. In his compilation is a higher education regulation, UGC notification, 435 at page 485. Therefore, my humble submission is, it is usual, I think unusual, for giving benefit of teaching experience for appointment of teachers in the government school. Yes. Now, it is not the case that in a appointment of, let us say, a footballer, a teaching experience is made a criteria. Then one can say no reasonable nexus for appointment footballers. But this is a case of experience as a teacher for being appointed as a teacher, appointed teacher. Therefore, there cannot be a dispute. It has got a reasonable nexus with the purpose of the act to find out suitable teacher for this. Now, this can be subdivided in many ways. If a rule has made which has or a marking system made which has reasonable nexus with the object and purpose, then that rules, if it incidentally benefit one class of candidates, that will not amount to bad rules or bad rules. Then comes their argument that all candidates here, as if fresh applicants and those, they are as if they are all equal. I am striking a root of this argument. They are not equals. See, my lord, why I say they are not equals. Firstly, my lord, the fresh applicants are not equal because they have no teaching experience in government school. If the applicant. Number 2, we have passed selection test of 2016, which freshers have not done. They have not passed any selection test of 2016. We have taught in the government school without any blemish, and that which they do not have. So, my lord, they are not having gone through the ordeal of selection test of 2016 and having come out successfully. They cannot claim they are not equal. They are unequals. Candidates are unequals. Classification date, the fresh applications are made with the full knowledge that if they do not have teaching experience and those who have teaching experience, they will get 10%. At the time of filing of the application, for selection, they did not raise an objection to this rule, the clause of that selection. No challenge was made. Knowing fully well that this discrimination, alleged discrimination, is being made, they have, without any prejudice, without any fetter, have joined the selection process. Now, this is one, they have knowingly done it, is nothing clandestine. Had this declaration been made teaching marks after admission of the applications, then thing would depend. It's knowing fully well. Now, next question is that can or those candidates who had not gone through the ordeal of 2016 selection process or those candidates who have not gone through the ordeals of 2016 selection process can be treated equally with those who have gone through the selection process and those who have been under order of Supreme Court is empowered to appear again, appear in selection process under order of court, Supreme Court. Therefore, they are not unequals. And if they are treated equally, that would have been violative of Article 14, because unequals cannot be treated as equal. We are a different class created by Supreme Court order, untainted class. We have suffered the 2016 selection process, all the remuneration. We have been given some benefit by Supreme Court and we are appearing express liberty given by Supreme Court. So we cannot be equated with the other applicants who had not gone through the ordeal of 2016 selection process. And had it been done, it would have been treating unequals with equals and would be violative Article 14.
Why did you not challenge this rules and submitted that you cannot be treated equally with the freshers? You all could have come up with a challenge.
I don't have a challenge. I don't challenge. Whatever right is given Supreme Court, we want preservation. And my argument is rule is in terms thereof. Rules do not take away any of my rights or benefit given by Supreme Court. Why should I? Kunta. Oh, করেছিল? Oh, I'm trying to correct it. I'm told, please correct. I didn't know.
If you kindly come to page 9 of our affidavit in opposition, we have given a chart of the WPA numbers wherein we have opposed to the said rules, my lords. But at that point of time, all our writ petitions were dismissed. It went up to Supreme Court also. The Honorable Supreme Court also dismissed the applications, my lords.
So,
We wanted for bifurcation of the rules, my lords. 2016 process should take place separately and 2025 should.
right. The process is changing.
Yes, my lords.
We want that, but held not entitled to it. And we accepted that.
Are the orders of the court annexed?
Liquid now.
It was all right.
It's
It was hard along with the Urnima's matter.
Ultimately, all the matters culminated in the 26th order, where liberty was granted to everyone. There are two sides to approach before your lordships.
But there is no challenge
Yet, because
At least there is
because
no
there is a
challenge.
difference between abilities of the councils to come very lightning speed and maybe little bit of slow. But today it's today hard December. Just matter.
Anybody with lightning speed with the challenge of the regulation from the old set? Not aware.
My lord, In fact, they held a conference with me also. I
In
suggested
stage of
it
preparation.
is in the stage.
All right.
Because the order, the SLPs which were there, some of the SLPs were with regard to grant us certain relaxations, because otherwise once you club it, what happens that we also lose.
Certainly.
We also
certainly.
lose, because we were under the impression whatever happened there would be limited to us.
Obviously.
So those are also there.
Vidhala is the old sale. Waiting candidate.
So means our prayer for being a separate selection test in regard to untainted candidates was not accepted by the court. There will be no separate selection test.
Some writ petitions are in the pipeline.
Yes.
Some are in the pipeline. You can think over.
So we did not claim any separate selection process. Court has said so. There could be one selection process. That helps.
The court never said there will be one selection process.
Court,
Because that was exactly your challenge.
court says that regard to untainted selection should be separate selection test in regard to untainted candidates of the first selection level to second. That we wanted it a mandamus declaring that. Court did not grant it.
Yes.
So there will be no everybody will be tried under the said rules of 2025.
Is it,
Everybody will be tried under the said
is it
rules.
proper?
Hmm.
Is it proper?
It is court has said so. I cannot say improper.
No. The Supreme Court has granted liberty to file fresh petitions, and everybody who has any grievance can approach the court.
Huh.
So you think it over.
But this order High Court refused. Supreme Court rejected SLP. So Supreme Court approved of this. That this rule, selection process, will govern both. With eyes wide open, that a 10% mark is allotted to a teaching experience. This is important. With eyes wide open, that 10% mark will be allotted for teaching experience, a maximum 10% mark.
All right.
So this is no longer permissible for them to raise this contention. The 10% mark should not be allowed to for teaching experience.
Should not be allowed, is not permissible.
This is no longer permissible for them to argue that, because court has said same rules will govern both. It only selection process, and it was then clearly stated in the rules, teaching experience 10%. That was the time for objecting for those who had said that I'm fresh application makers, that no, that should not be done. Teaching, no marks should be given for teaching experience. That was not done. They submitted application with knowledge of this teaching experience, 10% mark. But most important thing is, therefore, the conduct is this. The midstream, when the election, they have appeared in the written test also. Thereafter, they take the point that teaching experience should not be counted at all. Whether they can be permitted to urge the point. After having joined the selection process without any objection.
Yes.
In other words, can they ask for change of rule of game after they have joined the game and game has progressed? In our submission, should not be. But apart from that, we submit that is it, that this has no merit on substance, in substance. Why? They have not shown and not even argued that this teaching experience in a government school has no nexus with the selection of teachers for government schools. If the nexus is established, end of the matter. It cannot be arbitrary. Incidentally, some party may be benefited, some party may not be may be handicapped. As I give the instance of many things, not in the tender matters, usually 6 crores capital. You have second, maybe you have supplied similar goods to other government institutions. Therefore, those who have not supplied similar goods will not get the get open, cannot. But those have been held to be valid. Whenever those kind of conditions had nexus with the object, if the this work involve 10 crores or more. Similar main criteria, let us, they have not argued. There no nexus with the object. Next, I support Milord, 10% out of 100 is not disproportionate. Is not nobody is disproportionate mark. And in fact, Milord, several candidates who had no teaching as fresh candidates, they have scored marks more than the untainted candidates in the last written tests and the so it will not, you cannot say it will not tilt the balance. It's not so that had it been 50%, things like that. It's not.
There are scores of matter over here
Huh.
where only one mark is making the difference.
Yes.
Whether to participate in the interview or not. And 10 marks you say will not make a difference.
No. Yeah. That's 10 marks, Milord, is not the. Then there are 10 marks for academic qualification. 10 mark academic qualification. With
Academic is 60. The writing test is 60.
no academic qualification honors will BA, MA, B8, etc. Huh? Yeah?
Written examination is 60.
60.
Written examination is 60.
Let us see the schedule. Check up the schedule.
Academic is 10 and teaching experience is 10.
60 written test is the maximum. It is written test 60 marks out of 100.
Right. So we are not looking at the 100 stage now. We are looking at 60 plus 10 because here the interview list is published. And if you do not qualify, you do not go to the next stage.
That's the time. That is when come to the address your lordship. At what stage the marks will be allotted? What the purpose of interview list? To shortlist the candidates.
Right. So
Right.
the marks are added now.
Added now,
So
yes.
60 plus 10.
Even by plus 10 educational qualification, 10 marks, 70.
70.
70. And then Milord, out of 80, out of 80, 10 marks for teaching experience. It's not disproportionate. It is, nobody has said it disproportionate. So reduce it to 5 marks, nobody has said that. And in another case, if 5 marks is allowed. So, but let us, I'm arguing, submitting the arguments. Arguments, they have said no reasonable nexus. That nobody is argued. Nobody argued disproportionate. Is a case that's a course made out in the writ petition. But even then, now in the affidavit said, we are given instances where fresh candidates without this teaching experience have got more marks, total more marks than untainted candidates. So but this 10% mark is not a unsurmountable hurdle. It has been crossed by many fresh candidates. that will also give me a list at page 44 of our affidavit. Of fresh candidates. Categorized number of fresh candidates called for interview in different subject. This is list. How many?
Total is 9488 out of
No, similar.
20,000.
Page 44 also got it. Total number is 9,488
Out of
out of
20,000.
9,488 candidates, despite having no teaching experience, have been called for interview. So it has not factual support also. Arguments have been made in the petition. First of all, say why it is disproportionate factual expression. And now we are showing the fact as it actually happened, 9,488 candidates. After that, the argument disproportionate cannot be considered. They cannot argue. This point has not been adverted to by the learned friends. Now, please similar is not this. It has reasonable nexus. It cannot be called disproportionate or unreasonable. If I 10 marks will be 5 marks. Nobody's argument is that. Now, then, Miller, let us see what other grounds have taken for teaching experience marking. See the other grounds they have taken. They have what have argued. Yes. I have given instances of other institutions have similar mark for teaching experience. That we have given. It is not their case in the petition. That is very unusual. No other institution has allowed.
No, this
No such case.
Yes, what next?
Case. Then teaching experience not mentioned in Rule 2016. This argument made. What follows from that? That it was, the point is, because it was not mentioned in 2016 rules, then when new rules are framed, it cannot be mentioned. Then what's the purpose of making new rules? Now, please see on this aspect the judgment they have themselves cited. This standard of this reasonableness vary from year to year. They have cited a judgment reported in AIR 1986 Supreme Court 1444, paragraph 4 they have cited.
Yes.
See that paragraph? 4. Copy that over there.
It has been cited in that compilation. Bhim Sarkar.
It has, my lords, it has been submitted by the petitioners in Bhim Sarkar and Lubana.
ওই তিনখানা যেটা ছিল
কথা বললি তো টেলিফোনে টাইপ কর
Which one?
AIR 1986 Supreme Court
1444.
1444. Yes.
So the judgment on the premises tenancy act. Those who have tenant paying rent of 400, they will be out of tenancy act, and others will be. This was the case. Now, Lordship knows now on the premises tenancy act, there is that on the present act also. There have been. And at that time, in old time, court considered that this was not reasonable. Why? Please me not. Come to Millard, page 1448, where Supreme Court is saying, relying in middle of that paragraph on left-hand column.
How does it start?
And
How does the paragraph start?
SCT is like paragraph 4 starts, the counter affidavit does not exist.
All right. Yes.
And that is long paragraph, the only paragraph they relied upon. If you turn to the paragraph and come to the where 1984, 1 SCC 222 has been referred to.
Yes.
That portion. As held by this court in the 1984 1 SCC 222, a provision which was perfectly valid at the commencement of the Act could be challenged later on the ground of unconstitutionality and struck down on that basis. What was once a perfectly valid legislation may, in course of time, become discriminatory and liable to challenge on the ground of its being violated Article 14. After referring to some of the earlier cases, Justice Venkatramaya said, the garb of constitutionality, which it may have passed earlier, has become worn out, and its unconstitutionality is now brought out to successful challenge. Justice Rangam, etc., invite attention to some sentence in 74 Supreme Court. Then, what it says, then after quoting the observations, these observations were made in 1974, soon after amendment of Act of 73. They are made in different contexts and not etc. So, the test of varies. What was considered not necessary in 2016 may become necessary in 2025. A gap of 9 years. So that is because the 2016 rules, it has not make a teaching experience. It cannot be mentioned in 2025. This judgment has been followed, paragraph 4, in AIR 2005 Supreme Court, 202677, paragraph 58. The judgment of 5 judgments. Copy down, just please. Paragraph 58 at page 2698. Ito. Ito. It's a very এত করে judgment, না? হ্যাঁ? আচ্ছা দাও, এটা প্যারাগ্রাফটা বার করে দাও। Because SCC you are giving SCC online, therefore kindly find out the paragraph 58 in Liverpool, London. And Salve প্রত্যেকে এই জায়গাটা পড়ে Liverpool, yes. This is also paragraph 58 of the SCC online. In Liverpool and London SP 2004 9 SCC 512, this court observed, referring to motor general traders, another, first state of Andhra Pradesh and others, 1984 1 SCC 222. This is the judgment not of seen just now. The judgment is referred to Ratan Arya and others, state of Tamil Nadu and 83 SCC, and Synthetics and Chemicals Limited and others, and 1991 SCC. This court held at page 608, paragraph 49. There cannot be any doubt whatsoever that a law which was at one point of time constitutionally may be rendered unconstitutional because of passage of time. We may note that apart from the decision cited by Mr. Sanghi, recently a similar view has been taken by Kopila Hingadi, 2003, etc., and John Balmattan, etc. The Constitution of India is an ongoing document. It must be interpreted accordingly. In St. Francis Benjamin Statute interpretation, it is presumed that Parliament intends to the court will apply ongoing act, a construction that continuously updates its wrong wording to allow for changes. Since the act was centrally framed and updating construction, while it remains the law, it is to be treated as always speaking. This means that in its application on any date, the language of the Act, though necessarily embodied in its own time, is nevertheless to be construed in accordance with the need in treat it as a current law. Then page 70 also quoted in construing the ongoing, etc. So, what was not required in 2016 may become necessary in 2025. So therefore, in 2016, we did not make this teaching experience a mark. That doesn't mean if we make it in 2025, that teaching experience as a mark, a 10% mark, that will become invalid. We have to see, my lord. Best thing is see whether teaching experience has an intelligible different nexus with the object of finding out suitable teachers, selecting suitable teachers. That's the main object. What I did not require this teaching experience as a mark, maybe for various reasons. That's what the government can explain or commission can explain. But will not, that has first to be pleaded. Giving the has to be pleaded, then the state will be called upon to answer. But if it is not pleaded, no question of answer arises. Pleading is now gradually assuming more importance than it used to have in view of recent Supreme Court judgments. But I'm not on the technicality. Must be some reasons why it is, because it is very, very bold argument to say 2016 it was not mentioned, therefore cannot be mentioned in 2015. This is not an argument by itself, unless they have made no attempt to show that this teaching mark is very unusual. Nobody does it. And the teaching experience is not a reasonable nexus with the object of finding out suitable teachers in the government schools. Therefore, this argument in humble submission has no leg to stand on. Now, I've already submitted that this teaching experience is not confined to government school in West Bengal. Rule do not say so. Therefore, there is no discrimination. That only government school in West Bengal experience will be counted. Anybody, any come. Then your next also kindly consider the rules have been prepared by expert body, NCTE. They have not prepared the rules of 2016, maybe, may not be. Therefore, they prepared this rule in NCTE. And
these rules have been prepared by NCTE, by the state.
Commission. NCTE
The state.
expert body. State করেছে, but they can consult with NCTE frame করেছে তো. Expert body has consulted. Anyway, if I'm wrong, is anybody for the commission correct me? Was the
State
NCTE
has framed the
consulted?
rules.
Principal secretary not the
Correct me.
those
They have been taken into consideration.
principles have been taken into consideration, including NCT, because NCT obliges to not recognize degrees. Minimum eligibility criteria.
Ideas have been taken, not consulted. Not very good. I stand corrected, Mills. I can correct it. But normally they should have argued first, and I should have been normally. So, Mills, some of NCT ideas have been taken. That is all. Now, but then come to what is arbitrary? What is arbitrary? Well, kindly see 2002, Volume 2 Supreme Court cases, 188. Paragraph 25. Paragraph 25. No. ঠিক আছে আমার বেলা ডটকে দিলেই তো হলো প্যারাগ্রাফ 25 পাতাটা খুলে দিলেন না কেন? প্যারাগ্রাফে 25 It has been pleaded, as noted above, that withdrawal is without any rational or relevant consideration. Withdrawal is government, same thing. It has to be noted that this is the correct line of approach without a rational, relevant consideration. In this context, it has to be noted that the operators in state of Andhra Pradesh are required to pay the same tax as those registered in other states. Therefore, there cannot be any question of irrationality. The test of arbitrary action applicable to executive action do not necessarily apply to delegated legislation. Kindly note this. Applicable to what is applicable to executive action do not necessarily apply to delegated legislation. In order to strike down a delegated legislation as arbitrary, it has to be established that there is a manifest arbitrariness. In order to be described as arbitrary, it must be shown that it was not reasonable and manifestly arbitrary, not reasonable. Expression arbitrary means in an unreasonable manner, as fixed or done capriciously or at pleasure, without adequate determining principle, not founded in the nature of things, non rational, not done or acting according to reasons or judgment, depending on the will alone. In the present case, all the persons who are similarly situated, similarly affected by the change. That being so, there is no question of a discrimination place. So, therefore, the question is, can it be said to be unreasonable and capricious without any determining principle or nexus? I am humble. None of these tests have been sought to be fulfilled in this instant case. The teaching marks 10% is wholly arbitrary, is unreasonable, or it is done capriciously without has no nexus with the object. It has not been at all sought to be proved. There are other judgments they have themselves cited, which will rely on this field, on this aspect. Other judgments also. I'll come to those judgments cited by them when deal with judgment, I will show from their judgment also. So, this simply saying arbitrary is not enough. Have to be shown. Delegated legislation and executive action stand at different footing. Different footing.
So, according to you, this rule is a delegated legislation, and as such, it cannot be held to be arbitrary because the Parent Act remains. This is exactly your submission.
Parent Act, object, purpose
Object and the nexus
is being
and everything.
subserved. It is not being that I'm obliged, Lordship. I'll put my submission as my Lord, taking a cue from my Lord's observation. I put it negatively now. It is nobody's case that allotting of 10 marks for teaching experience will prevent selection of suitable teachers. That is to I stand corrected. That argument has to be made, and court was satisfied. That allotment of 10 marks, teaching experience, will stand in the way of selection of suitable teachers. That is, should be the test of the matter. And that nobody has said so. It's standing in the way of. Then, in other words, he has no nexus. It will defeat. It will defeat the purpose of the act or the rules, namely selection of suitable teachers.
Yes.
Next point has been taken that experience of 9 and 10 can consider for 12 and 11 and 12. That's considered. But that one minute, say minute, has answered by Dr. Gurushami very competently. He has shown the experience in secondary education. Classification is, under West Bengal law, classification is between primary, secondary, and higher. Secondary includes both 9, 10, and 11, 12. Therefore, this court cannot be asked to make a classification within class. That is the answer given to Dr. Guru Shamilat, which I need not repeat. I adopt that. Then, next ground attack is
I just let you know that there is one writ petition filed by the 11-12 candidates that the 9-10 experience cannot be treated to be taken as experience for teaching 11 and 12. This writ petition is also there.
that is feeding that answer is
That is a petition.
that's right.
I just let you know.
Therefore, will not therefore
So
teaching
all types are here.
Therefore, Milord, this argument is based on an admission that marks can be given for teaching experience.
No, the candidates are
That's
job losers.
Marks can be given for teaching
There
experience.
the rule is not under challenge.
And then, but while giving the marks, you find out, did you teach in 9, 10? Very good. I'll give you these 10 marks if you are a candidate for 9, 10. Marks can be given. Enough for me. Enough for me.
You and those candidates are on the same footing.
But help us, that's enough for me. Therefore, not, if it is both as part of secondary education, 9, 10, 10, 11, then why make this classification? Why classification made by the legislature? And how can you ask the court to make a sub-classification? Court cannot differentiate between 9 and 10 and 10 and 11, 11 and 12, because they're all part of one class, secondary education. Court has the rule, our act do not say secondary education part 1, secondary education part 2. Therefore, this approach is not permissible. Is that when the legislature has made a classification and clubbed together 9, 10 and 11, 12, clubbed together to form one class, how can they ask to make it dissect it and make another class? This cannot be permissible law. That was the argument of Mr. Guru Swami, which I adopted. Which I say nothing new I'm arguing. Next ground is taken, level playing field. What is meant by level playing field? I do not know really. I'm not so much level-headed. No, level playing field. I'm trying to ascertain what is level playing field. At the time of being invited to join the selection process, all candidates were told what is the rule of this field, what is the field. If you join this game, this is your field. It will be 100 years or 200 years field or whatever maybe. You will get 10% at 10% if you have teaching experience or government schools. If you don't have, you don't get it. So level playing field is the candidates must be made aware of the playing field and the rules. Level playing field, what does it mean? It is based on rule of law, the level playing field, that there must be certainty of the rules of game. Level playing idea is based on the rule of law. The rule of law says there must be certainty, the crux of the rule of law. That must be followed. I am humbly submitting the certainty is clearly stated in the rules. You like it or not, don't like it, don't participate. Don't participate. Or to come and challenge it immediately. But we must make the rules of the game certain. That we have made certain. Next answer to this is that is 10 marks teaching is not an eligibility criteria. That is important. Gates are open to everybody. Had the rule been that only teaching experience persons, 5 years or so much, will be allowed to participate, then thing would have been different. Level playing field, they can know why others are not being allowed. But with all the judgments they have cited, if you find, Milord, they are all cases of eligibility criteria. Getting, not opening the gate fully, but shut the gate for some people. Eligibility criteria. When I deal with their case, I'll show that the eligibility criteria is to must not shut out, and it is level playing field apply to that, not irrelevant. Then Mirror, no judgment has been cited what is meant by level playing field, but we shall endeavor to do so. Then my next point is that the rules are contrary to regulation of 1998. Is another ground of saying the rule is ultra vires. Rule is contrary to regulation of 1998. Kindly see the regulation of 1998. Dr. Veda Valuta. Similar heading. The regulation, the name is very, very long name. West Bengal School Service Commission procedure for selection of persons for appointment to the posts of teachers, including headmasters, headmistresses, superintendent of senior madrasa in recognized non-government aided schools, and procedure of conduct or regulation. This is for selection of teachers or maybe for madrasa. Firstly, my lord. Now, this rule has been made out under Section 18. In exercise of power, conferred Section 18 of the Act, Service Commission may hereby make the previous action. That Act is quoted. Definition shall have same assigned to Original School Service Commission Act. Now, Section 18 also remembers of the Act. Section 18, please come back to me, Lord. Power to make regulation. Central Commission may, with the previous approval of state government, make regulation not inconsistent with the provisions of this Act or the rules made thereunder for discharging the functions of the Commission under this Act. Compare this Rule 17. State government by notification. No, Central Commission is not making that rules. State government is to make the notification, make rules carrying out purpose of this Act. Regulation is made by Central Commission with the approval of a state government. And the regulation cannot be inconsistent with the rules. So in case of inconsistency, if any, the rules will prevail. Regulation cannot make an rules ultra vires. Is on the reverse. Rule can make a regulation ultra vires or not. Secondly, Milord, this regulation operates in a different field, madrasa. And ours is government schools, government schools, not madrasa. So, Milord, it is not a proper argument to make that regulation is even if it is assumed to be contrary to any regulation, rules, the rules will prevail. So the argument has no leg to stand upon. Next, similar to the next point, they are arguing that they have argued rather. They have argued that actually point বাকি আছে না না আমাদের point ওদের রুল গেল টিচিং এক্সপিরিয়েন্স বলেছে level playing field experience of 9 and 10. Let me now start dealing with the judgment they have cited. From those judgment, how does it help them or help to support the humble submission of mind regarding proposition of law? The 2025 7 SCC 705, paragraph 39, they have cited. Mr. Vikas Bhattacharya just cited this judgment. Okay. আমার কপিটা দাও এটা আমার কপি
2025 7 SCC.
2025 7 SCC 705. Yes, Milord. 7. It will also be given Supreme Court cases or the SCC online.
Find out.
SCC, yeah.
Find out.
Your Lordship's may permit, may I give you a copy right now and have a copy?
No,
Again,
because mark
multiple
code, no.
copies.
Court will mark it.
If it is here, then it
Mark
must
it.
be here.
Lordship needs at least 4 or 5 juniors. Hand over.
Yes, 529. It's there.
আমার বিপ থেকে দাও না এই যে আমার বিপ থেকে জামিনটা বার করে দাও আমার দাগ দেওয়া তোমার
Compilation serial number.
Yes, I've got it.
18.
529. Yes.
Got it, Milord?
Yes.
Paragraph 39, Mr. Bhattacharya has relied upon this. 39. It cannot be again said the factors of when, which, what, who, and how that are associated with a recruitment selection process is the prerogative of the recruiting authority and the selectors. However, this is first prerogative. However, at the same time, the process has to be conducted consistent with the statutory provisions governing the same. So, I rely on this. They cannot make selection contrary to the rules. if any, as well as principle of absolute fairness and complete. Because we'll point out here, in this case, there's no rules. Also, you find that in paragraph 40, can you go to paragraph 40? Then I'll come back to paragraph 39. In this case, there's no rules. There's a main distinction. Be that as it may, drawing from our joint experience on the bench, we can say with some degree of conviction and authority that conducting recruitment process in terms of executive orders and in the absence of statutory prescribed standards more often than not invite avoidable litigations. There are no rules were there. They now come back to paragraph 39 as well as principle of absolute fairness. Though it is true that the law does not postulate a fetter on the authority of the employer state, and it is within the domain of the government when to initiate a process of recruitment for public employment, either according to recruitment rules or even in the absence thereof. It is for the government of the day to decide in which manner it proposes to conduct selection. What would be the various stages the candidates aspiring for appointment have to pass through in order to be placed in the select list? Who would be the selectors and how weightage is to be given to each of the testing methods? A great deal of credence is lent to the process if it is fairly and transparently conducted in accordance with rules, whatever be the source, without the slightest hint of any bias or favoritism or nepotism. Full stop. So, my lord, the rules must set how weightage to be given to each of the testing methods. Weightage to be given to what? It must be disclosed. Then, normally, it is not for the courts to interfere unless the process smacks of malafide. However, the right to be considered for public employment being a fundamental right, it will be safe and prudent to have recruitment rules to govern the process of selection so that best possible talent is appointed in public service. That's the Mullah I'm saying. Suitability and best from service. Teaching experience for being appointed as a teacher. That's what that's what I'm saying. Obviously, assessing the merits of the candidates aspiring for public employment on the basis of a prescribed standard would not only provide a level playing ground field, this is for each of them, there exists excellence of any institution to which appointment is to be made would depend directly on the proficiency of its members, staff, and that would in turn depend on the quality and merit of those who offer themselves for selection and ultimately get selected, necessitating the selection to be conducted without any hidden taint or masked malafide. Last but not the least, having regard to the present times when the corruption has been held to be a work of life by certain responsible citizens of the country, very sad thing, but correct. It would have been desirable if the process of recruitment of 104 candidates was conducted after framing of recruitment rules and also prescribing the written examination to keep the process absolutely above board. It supports me, my lord. I respectfully support me because in this case, my lord, there are no rules. There are rules. And selection process was challenged. Not any rules giving any wages to anybody. Now selection process is subject matter of challenge. But what is challenge is giving weightage to each and every testing method. Which testing method. And court says it is a government priority. Priority doesn't mean freedom to do anything. That I agree. But then it comes to be, court will start with a presumption of validity. This is law, 114E, Evidence Act also, sorry, should,
How much more time are you likely to take?
but can you tell me how much more time I should take?
It is up to
I
you.
should take. His Lordship is the best judge.
It is up to you, sir. You are nearly over
May
because
I continue tomorrow? May I continue tomorrow? Or
tomorrow I don't think.
whatever date?
Maybe on Friday it will be all right, but not tomorrow.
Friday. Or Thursday, not possible.
No, sir. Tomorrow I've got applications and it will not be possible.
Okay. Friday. In the first part of the morning, will it? The Friday, I've got one small matter for half an hour at 2 p.m. That's why I'm asking, Milord. I can ask the learned judge to push it off, or
Let me see.
my preference of this matter, Milord. So many persons' life is depending on this matter.
Certainly.
That's why if Thursday is not possible, then Friday, Milord, give it pretty high up. So I can finish before lunch and recess.
This matter is fairly at the top.
But depends on the other matter. Some unexpectedly, legitimate expectation sometimes is not fulfilled. Some matters takes more time. In the found that item 7 was going on for a long time. I was waiting for it. Anyway, court's convenience come first. Then I shall adjust, have to adjust.
Because you are already over, just distinguishing
That's
the
right. I have to
judgments.
deal with the judgments.
Possibly it will take much more time.
I'm only answering the argument, nothing more. I go point to point. My task has been somewhat reduced by Dr. Guru Swami. That has given. Thank you.
All right. Next is Mr. Dhor's turn. Is it your turn next?
Yes.
Mr. Dhod,
In that case,
my deficiencies will be made up by Mr. Dhod. My deficiency will be made up by Mr. Dhod.
If there is any. Hello, that would be one line order, identical order. In there is a little separate applications, even better candidates who got the benefit of they had an earlier job. Now, because of these confusions, many of them, the headmasters are saying that let the court decide, thereafter we would allow you to join. So these are the circles. So they made an application. So kindly I just
let the court decide. The Supreme Court has decided already.
Supreme Court has decided for
reverting them.
No, question is whether many of them, there are total 8 counselings. Now, majority of those counselings, in fact, tainted were mostly in the first counselings, which was, but that's nothing to do with. Now, majority of them
Yes.
are from first counselling to 7th counselling.
All right.
Now, if Lordship holds that those who were appointed after second counselling, because first and second were within time, third, fourth, fifth, sixth, seventh, those were
That has not been argued also.
I will argue that why I say that the Supreme Court has 100% clarified that who are tainted and who are not tainted.
That is different. I'll come to that.
But that matter is coming on 10th, I suppose. The matter regarding expiry panel candidates, it is coming on 10th before your lordship.
No, expiry panel.
That Sir, you can leave.
I can go.
Yes. I'll keep it on Friday.
Friday, in the first half.
And at a higher position in the list so that you can make your submission. And in case it doesn't take up, then it is an understanding during recess, I'll take it up so that you can be relieved in the second half.
Yes. Second, that will be take half an hour maximum. But some court has a practice of hearing matter for short while, in a piecemeal manner. For the benefit of the lawyers and to the detriment of litigant.
In this matter, I
may take my last leave.
Yes.
I'm seeking kind leave to correct the fact sheet of the affidavit in opposition.
আমারটা একটা
This
কোথায়
matter,
গেল, এটা
one of
কোথায়
our
গেল,
this matter.
আমার বিপটা কোথায় গেল?
You have mentioned the wrong number.
No, no, no. The name has been
Wrongly.
fact sheet. It's the fact sheet.
What is the name that you have mentioned?
Saikat Mondol is the name.
Uh,
The applicant who has been added as a party.
yes.
The fact sheet, it has been wrongly typed as Shipra Mai.
দেখুন তো এটা খুঁজে পান কিনা
Yes, but it has been handed up to your lordship, madam.
today
Yes.
তাহলে ওপরেই আছে
Due to learned advocate general is
এইটা
in the
এনাকে ফেরত দিয়ে দিন, এইটা এনাকে ফেরত দিন, মিস্টার ধরকে এটা ফেরত দিন।
learned advocate general is in the
Oh, one minute.
VC.
1 minute. This was not required. Mr. Mitros Jr. will please take this back. This was not required. Yes,
Madam,
the AG want to
May I
submit something?
May I mention, because I mentioned, because item number 13, my lord will remember that where matter will be, my lord, whether it's sat or the.
But the tribunal matter, my lord, your lordship was pleased to release the matter initially on my submission that it ought to go before the tribunal. My learned friend's contention was there is no judicial member in the tribunal. My submission was that one must file a petition before the tribunal and then come to the High Court. My lord was pleased to prima facie agree with me and pass an order. Thereafter, I think the matter was mentioned once again, and today, my lord, it's appearing in the list.
Learned AG, 1 minute. May I finish with this and then hear that?
Right.
That will be beneficial for, because otherwise, my lord, it will be jumped. I will cite
Right. So please wait, let me pass an order in this matter.
item number 13, it may be,
Item 15.
that is jurisdictional issue, alternate.
But submission made on behalf of the applicant in Can 1 of 2025. Yes, sir. As the recruitment rule pursuant to which the ongoing recruitment process is taking place under challenge, and the parties are at the stage of advancing arguments, the commission is directed to publish a public notice. Commission, please, are you here?
Yes. My lord, we are here.
Oh, yes, you are turning that side. I missed.
In which matter? My lord, in 515.
The commission is directed to publish a public notice disclosing pendency of the writ petition, clearly indicating that the fate of the recruitment process shall abide by the result of the writ petition. Stop. The said notice is required to be published so that none can claim any right or equity even after the conclusion of the selection process. Stop. After the selection process, no, not even after. If the selection process concludes prior to passing a final judgment in the instant matter. List for further hearing, 5th.
My lord, any outer limit for publication?
Do it immediately. Why I say, why I say so
that we are not in any difficulty.
none is in any difficulty.
Right.
That's the
Otherwise, see, we are in the midst of a hearing.
And only one submission, my lord. It is understood that, my lord, all these, my learned friends are going to make submissions on Friday in item number 15.
Or
And
not know, but
some of them. So, my lord, my senior, Mr. Bandyopadhyay, is in difficulty on Friday. My lord, whatever, my lord, happens.
on the next day. I'll hear.
But I'll be addressing that after. Kindly permit me to address after Mr. Dhar, or before Mr. Dhar, whichever your lordship feels would.
no. There was an understanding that lordship that
You on the first day
Because you are a
submitted that
neutral.
you wanted to argue after all these applicants and
Right. Very good.
Because,
Yes,
my lord, I don't think Friday will be complete. Mr. Sannal is there.
it will certainly not be complete, and that is the reason this today's publication order is being passed. Because Supreme Court has set a deadline. the commission will be bound to follow that. Now, Supreme Court has also passed on a very onerous task on the court to hear all these matters and decide. And within 1 month, it is absolutely impossible. Not even 1 month, 3
No.
weeks prior to the vacation. It is
Have only,
impossible.
It is.
18, 19 working days.
So it's absolutely impossible.
madam.
So many
This is-
candidates
this
to
is-
be heard. It will certainly take time.
Not even 18, 14 working days.
So whatever, let it be made public that this matter is going on. None can claim any equity, and nobody will at least feel that no, I didn't know that the matter was there. Let there be a public notice.
Yes.
And then whatever happens,
Correct,
happens.
correct.
But it will be.
Yes, now the Advocate General, we are over with 15.
I was.
Malad,
In Bhim Sarkar, your lordship is not passing anything.
Order will
No,
cover.
no. He wanted to come up with that application Can 7 or something.
Wait, I'm hearing Mr. AG in some other matter. Just wait, I'm not rising, sir. You all hardly leave me at 1:15 and at 4:30. Hardly. Yes, AG.
But I think Mr. Shamim wants to say something. I am
I
okay with the
think-
matter being fixed on any day, Milord, as per the convenience of the court.
Yes. I am.
It's absolutely inconvenient.
So next week, or because that matter is going on, and another thing is that, my lord, because it's fallen from my lord, this court, my lord, there is public notice regarding other matter, my lord. They make this public notice in 2 newspapers. One is that in English and
Published in the official
website.
of the
Yes, as my lord deemed fit.
যেখানে বললাম না published in the
Official.
official
Oh,
website
yes,
of the
madam, that-
commission.
Yes.
That is the
that-
most
yes.
transparent way.
More transparent.
But then item 13, no date fixing.
Yes, my lord. Then my lord,
Item 15 you want?
Post-
Need for correction of back sheet.
Back sheet.
my lord, item number
In opposition.
my lord, item number
পাওয়া
13,
গেছে?
then
ওনার oppositionটা কি পাওয়া গেছে? টেবিলেই থাকবে। এটাকে আগে
my lord, then item number 13 may be posted in next week. Item number 13 may be posted in next week. Next week or?
let it remain.
Oh, yes, my lord.
And,
Yes.
as and when it appears, we can
yes.
pass necessary orders because changing the position of the list will be difficult.
Well, should I keep the opposition with me? Because I was thinking the difficulty in finding out. Now I have served to the other side, so that's why I learned it, friend. It would be better that instead of, because burden we can clearly understand. So it's served on, I will give, that would be better. Couple,
What thing?
the oppositions are there,
Yes.
affirmed, also served to the respective parties.
Yes. As and when matter comes up, you.
That's item.
Yes,
So that it can,
I'm not passing order
Yes,
in any
yes,
matter. It's
yes.
only in this matter, item 15, that the order is being
yes,
passed.
yes.
Fact sheet power আছে? Vision.
I say that nothing in item number 21, kindly pass 1 line order, add can number 7. Do not hear me today. Once I finish for everyone, thereafter there is a little small group who stand even higher footing. So today's I am praying, kindly allow the can.
Allow. But I am not allowing, is the can there in the list?
It is in the list. It is in the list.
Let it take it that it will
I understand.
be prepared,
Correct,
not
correct.
passing any.
I understand. Well,
Because any order
Oh,
passed,
Going, the file will go. Yes.
signing, checking,
Ma'am, I do understand.
there.
Once you finish
Application.
all, then
In can দেখে নেবেন of 2025 correct the back sheet of the affidavit in opposition filed in court today. আজকে কি একটাই opposition file হয়েছে না আর কিছু ফাইল হয়েছে?
We have filed in Shishi. Item number কত শিশিরটা? 19.
আমার কাছেও আছে তো টা?
I'll file it today, please take it.
It is already taken on
in
record.
fact,
We have kept it with the record.
In fact,
1 line.
here I also have affirm sub, but I have not
All right,
given
then
because
fine.
it is better I keep it. Otherwise, my lord, it would be difficult for the
পাওয়া গেছে
officers.
দেখে দিয়েছে
Yes, yes.
As and when matter comes up,
Then we'll give.
And your lordship
Yes.
has to allow.
please do.
Hey,
Otherwise, it will
No,
not be recorded. It
I
will
understand.
Very
I
good.
understand.
Yes, yes.
Why is he? What is your name? Why is your name not reflected in the order sheet? I do not see his name in the order sheet. I do not know the reason why. You put in the slips adding names of persons who are not there in court.
Just remember this, when you will become old like us, you will
No, Mr.
cherish.
Dhod is not old, Milord. I
No,
beg
no.
to differ.
I'm much older. I say that.
Taking the example
No, no.
for himself.
I'm saying.
No.
I say.
Let me turn this off, Milord. I'll say.
I say that when we'll Milord become very senior one, we will cherish this moment. You'll understand the human part of the justice delivery.
Great.
Good.